Ms. Gunn?
No, that's what
I'm sorry, I don't know that I yielded.
Well, I'm sorry, sir, you can
Yeah,
tell.
I don't know that I yielded. And so it's my understanding also, Mr. Morosic, that you and Attorney Weems have agreed to a 3-hour hearing, which means that is that correct?
Okay.
Yes, by way of background, Ms. Wilson is represented by Antavius Weems, and we have conferred in detail. We've reached a number of agreements, as lawyers should, on some of the preliminary matters. For example, we both agreed on the hearing officer, Judge Thelma White Moore, who's agreed to serve as hearing officer if the council appoints her. And we've agreed on a number of items, including, for example, that the hearing be confined to 3 hours. The location, we both did not know what the council's preference was. It may well be because this break room may not be big enough. We don't know. We're both happy. Attorney Williams is not here.
He's in progress.
Okay, right, he'll be coming. Let him speak for himself, but I believe he would not have any objections to the break room here.
So I bring that up for 2 reasons. One, Madam Clerk, I've never known for a meeting to be rescheduled without checking in with council, for a meeting location to be moved. We have met at Welcome All Park before, but we usually check in with council. That's neither here nor there, though, because we're going to have to republish the notice of meeting anyway. If this meeting is scheduled for 5 o'clock and it runs until 8, then that's 3 hours, which means that we won't be able to start our council meeting until 8 o'clock. And so we should be thinking about, we're going to have to redo them anyway, and so I don't feel that Welcome All Park is an appropriate location for this hearing. And now I'm done.
Okay, Ms. Gunn?
So, what about our regular meeting and business that we have to do on that same day? So we're not going to have a work session at 5 o'clock, and we're not going to attend to any other business until 8 o'clock?
That was discussed at the last meeting.
That part I missed then, because I don't remember. I was here.
Madam Clerk, if you...
Yeah, it was discussed.
We, again, when we had the last November meeting, and we said we were going to have the meeting on the 10th, we were notified by South Fulton Service Center that they were not available. I sent out the email to let you all know. So I took it upon myself to find a place for the council meeting to be held. And I checked with Mr. Donald, and we both agreed on Welcome All Park. Now last week, right, that was separate from this hearing. Last week, you all made the motion to have the hearing on the same day. We went back and checked the minutes, and the motion was made that the regular meeting be changed to the 10th. We have the regular meeting at the 10th, but you made clarification that the motion was made to approve the December 10th meeting as a regular meeting, and Councilmember Khalid clarified that the December 10th meeting will consist of a work session at 5 p.m., executive session at 6 p.m., and the regular meeting at 7 p.m. The motion was approved. Now, I sent this back out to you all on Wednesday morning just to clarify what the motion was about the December 10th meeting, so that everybody would know what the motion was and how it happened. So I do not know whether or not you're going to have the council meeting now.
Okay, I just need to...
Okay, Ms. Gilliard?
I was one of the folks that responded when the email came out that it should be held, the meeting should be held at Welcome All Park because Stone Motel was not available. And I do believe that because of the seriousness of what we're dealing with, that it needs to be in a neutral location so we're not having any drama.
Okay, Ms. Jackson. I
And
have
she-
you, Ms. Garral.
In choosing the hearing officer, I do understand that you did say that you and Mr. Weems would be making that decision. But, in other words, I just assumed, I guess, that you would be coming back to council
That's one of the items on today's,
if we agree with this particular individual?
yes.
Okay, thank you.
Okay, Ms. Rowell.
Just to clarify, this document we have dated November 26th, is this an official statement, or is this information gathered from news coverage, or was that from communication with Mr. Nash?
Which document are you referring to?
The short summary of events.
Or is that has anything to do with the moving of the big meeting?
Well, we can stick to that.
Yeah, let's speak to that.
Okay.
It's just something that I received from the Fulton County Development Authority attorney, and I tried to send it to the entire council. I thought I sent it to everyone via PDF. I don't know if that happened, so I'm giving you a hard copy today.
Well, counsel, it's not germane to the issue we're talking to now.
Yes, sir.
She understands that.
Yes, sir.
And
Robert,
so you still have the floor.
I don't have anything relative to the meeting location.
Okay, Ms. Willis.
I'm not understanding what neutral means. I mean, we have our council meetings at Stonewall Hotel, which is in my district. We've had, a council meeting at Welcome All Park, so I'm not really understanding what neutral means. This city hall location is not gonna be large enough to accommodate, the residents. So it can't be one-sided. I guess I'm trying to figure out neutral to who. Neutral is, I mean, it's gonna end up, wherever we have the meeting, it's gonna be in someone's district.
Okay, so let's do this. I think your last point is well taken. It's going to be in somebody else's district. I will assume by someone making a motion here that there will be 4 votes to accommodate that motion. I think we need to move on.
Yeah.
Go ahead.
I'd like to make a motion that the meeting be held at Burdette Park.
Second.
Properly moved and second. Discussion. Hearing none.
Yeah, I have a discussion. Is Southwest Art Center completely out of the picture? I did ask.
No one recommended that.
Well, actually, I was trying to.
We sent
I
a
spoke to
notice to the clerk's office just asking or looking into it, but I don't think they've had enough time to look into it just yet.
Okay, there's a motion on the floor.
And
Any further discussion? Mr. Baker, you finished?
I think I got one consideration.
I would like to hear what the city manager and council has to say.
I just think that there's one consideration that you do have a meeting scheduled at the same time, on the same date. So whatever changes you make, you have to, because you don't want to have to leave Burdette Park at, let's say, 6 o'clock or 6:30, 6:45 to make it back to, I think you've got the regular meeting at Welcome All Park at 7. It's just not going to work. So whatever adjustments you make, they have to entail both meetings. Even if you have to move one up for an hour or whatever it is, you've got to make a holistic decision on the location because you're impacting both.
Okay. Council, did you have something to share?
I would just ask that if the motion specifies the location, if you could also specify the address. I know that Burdette Park is probably known to most, but I'd like to specify what the address is.
Well, we're going to say that, but I also wanted to ask if Councilwoman Gilliard would consider to add a friendly amendment to include having our council meeting there as well.
At where?
Yes, immediately following said
Yes.
hearing.
Yes.
I yield.
Any further discussion? All right. Let's go ahead, Mr. Khalid.
Actually, I think Dr. Rowell's hands up first. I'll go after
I didn't see her hand. Go ahead, Mr. Rowell.
So I'm going to say the action that's being proposed will impact residents of District 3. Given the fact that we just had an election and this is action that's being brought forth as a result of action proposed by some members of the city council, I think it is reasonable that you would want the people who would be directly impacted to have access to the hearings. So for that reason, I don't see why you would move it from the area that's going to potentially lose their representative.
Okay. Mr. Khalid?
I don't know, we were talking about development just last week. I was told that the decisions that we make about development impact the entire city. And I'm wondering, I feel like we're rushing through this. I'm wondering if Councilwoman Gilliard would consider withdrawing her motion, that we could have a substitute motion to take 15 or 20 minutes to contact these places whose names we're throwing out to see if they are even available at that time. It sounds like our clerk hasn't had time to do that, but I'm sure if we took 20 minutes, we could get our parks manager on the phone, we could get the Southwest Arts Center manager on the phone and just figure out who is available, when and where. And perhaps we don't have it in the city at all. Maybe we have it at the gathering spot. Maybe we have it at the Cascade United Methodist Church so that it's not in anyone's district. But we can't really do that unless we take some time to figure that out. So I think that it's worth taking 20 minutes to try.
I second that substitute motion.
That's not what we made.
He did.
He asked for her to.
So that is my I will make that substitute motion.
I second.
What is your substitute motion?
That we have a 20-minute recess to contact some of these facilities.
50.
I have a friendly.
Go ahead, please, please.
Instead of us having a recess, how about we ask the clerk's office to do it within those 15 minutes if we continue?
I think if there are multiple locations and there are multiples of us, then we all could be making calls.
Let me say this. This is what we should have done in the first place. Before this meeting ever started, before they hit our agenda, it should have been doing. That's what I was trying to say. So if you have something, I agree with Mr. Khalid on this. If you have a particular place, give it to the clerk, let the clerk go out and call the places and find out who can do it.
Well, I think they said they had asked her.
No, he said this.
Oh, just, you just asked.
Yeah.
Yeah, we just got the request, so we just.
I don't know how this got on here like this, but it's not the way we usually do business.
This is not usually what we're doing.
Go ahead, sir, you want to say something?
No, Your Honor, it was my suggestion that these matters be considered.
Okay. All right, in discussion, there's a substitute motion. Any discussion? All those in favor of the substitute motion?
Are we taking a recess?
20 minutes.
Wait a minute, that passes. Are you voting, Johns?
I did, I voted.
Okay.
Let's go ahead.
So we got some people checking on Southwest Arts Center. You mentioned that one. What others are we looking at?
It's going to be just talking with
He's kicking his. I want some pizza. He's fighting for his pizza. You can't have no pizza. You know, they.
Got the motion to reconvene?
Please.
Anybody want to reconvene?
I'd like to make a motion to reconvene.
All right, properly moved second. Any discussion? All those in favor? Okay, Madam Clerk, what you come up with?
Well, we called, between Miss Chris and I, we called Southwest Arts Center. They've got production going on there. Also at South Fulton Arts Center, there's production, so the theater is not available. We called Wolf Creek. Wolf Creek, their multipurpose room is available, can hold 100 people, and is available from 2 to 6 p.m., and 6 p.m. is a hard, gotta be out of there. And Burdette Park is only available right now from 2 to 6. They have a 6 p.m. online application. And Mr. Adams checked on
Yeah, I also called the Aviation Community Culture Center, spoke to the director there. She did advise that it is available. She did give me a soft approval that we can meet there from, I gave her the time frame 3 to 9. They did ask that since it's after hours that the meeting not go too long, but we do have a soft approval. I just received the application, which they want us to fill out, but that is an option that is available.
Okay,
And it is subject to cost as well. Just wanted to put that on the
Did
record.
she give you a cost?
She did not. She just said the rental cost plus staff.
Okay. You've heard the options. Anybody want to?
Yes, I'd like to make a motion.
Go ahead, sir.
I spoke with Tony Phillips on the break, and I think Councilman Gilliard spoke with some people as well. So Cliftondale, the building is available. It holds 175 people, so I would like to make a motion to have the hearing at the Cliftondale building to be followed by the council meeting Tuesday, December 10th at 5 p.m. And that the address of that building is 4645 Butner Road, South Fulton, 30349.
Second.
Been properly moved to second. Discussion. Hearing none. All those in favor?
Discussion.
You have a discussion? Excuse me.
Sorry.
You have a discussion.
Where exactly? The South Butner Road or Cliftondale, the building? So the
It's next to
school,
that. It's right there.
right,
Okay?
100. And what about chairs and?
All right. All right, let me see the vote again, please.
Mayor?
I have a question. So the hearing is starting at 5.
The meeting will follow the hearing. That was the motion.
So there is no work session. I'm
There is
just
no
being
work
clear
session.
because
Yes,
it's have
there is no work session, just
No
a
work
regular
session.
meeting.
Well, it's gotta be part of the motion now.
Well, the motion was for the hearing to start at 5 with the regular meeting following the hearing.
Y'all not gonna have no parking at Cliftondale.
I'm gonna say I have a problem with not taking care of our city business in response to the action that the hired attorney indicated. The activity is not criminal. We're really putting aside our regular business, and we only had one meeting last month. We were supposed to have one meeting this month. I don't think that's appropriate.
I'm sorry, point of order. We've had the vote and it passed. Is that correct?
No.
Yes, sir.
No,
She asked for a discussion.
I
You know,
don't
you
think
did-
Oh, we're having a
acceptable
post-vote
for
discussion.
not
That's
to
new.
have- I
Okay.
still had a
Okay.
floor. I still had a floor.
Had already
We
voted.
should not be putting aside city business. We had one meeting in November and we're having one in December.
Okay. Let's see again. Let's see hands on the vote. That passes. Madam Clerk?
Okay.
That vote was 4-3, right? Okay.
Yes. Next item is council approval of the designation of hearing officer.
You want to address that or use one of your?
Yeah, and I'll allow Attorney Weems if you'd like to address council on what we've discussed.
I don't know.
Okay.
This is about the hearing officer, right?
Correct.
Okay.
And it.
Why don't you stand with me?
Pardon?
Why don't we do it together?
Yes, sir.
No, this is about the hearing officer.
Yes.
Okay.
Yes. Myself and Attorney Morris actually contacted a number of people who all really didn't want to get involved. But we were able to find a couple of people who would serve. One person said it would be $1,150 an hour with a minimum of 4 hours. And the other person said about $700 an hour. $7,500 an hour, a day is what it, $7,500 a day. And then we were able to agree on retired Judge Delma Wyatt Moore, who was a judge of Superior Court for
Fulton County Superior Court judge, well qualified, Well capable.
Yeah, so we both talked with her together, contacted her with some convincing. She said that she'd be happy to serve. Her rate is about $500. Well, it was higher because she sits as a retired judge, but we were able to ask her to reduce that down to $500 an hour, which she did, and she certainly will make herself available to assist us in this effort.
Thank you. Is there a motion or comment, please?
Yeah.
Go ahead.
Sure.
So my question is, so explain to me exactly what the hearing officer is going to do.
The hearing officer's role would be to preside over the hearing. At the end of the day, this August body will be the jury to make the determination of what, if any, violation that would have been. She would decide any preliminary issues that we have prior to the 10th. And then ultimately, once we get to the 10th, she just is a referee to keep it in order.
Okay.
Mr. Baker.
I'd like to make a motion to approve the presiding hearing officer as set forth by both legal counsels.
Second.
Properly moved and second. Any discussion? Hearing none, all those in favor? Am I getting anything? Okay. That passes. That unanimous? Yes, that's unanimous. A unanimous vote?
Yes.
Thank you.
It happens sometimes.
Next item is council approval to consider the waiver of executive session privilege.
There's two issues that the council will at some point need to consider, either today or at the beginning of the investigative hearing or during the investigative hearing. I think I speak for council. We would like some kind of a vote from council beforehand so we can prepare our cases. As I indicated a week ago, the Georgia Open Meetings Laws requires you to hear the evidence in public. And the third phase, when you make your decision, it must be in public. What you do during the debate and argument and deliberation, being a personnel matter, the council may choose to do so confidentially or in public. That's the first issue we'd like council to decide. And let me just say, Judge Moore is important because this is essentially a jury trial. And jury trials go on as long as weeks in some cases. Council and I agree procedurally that we want to confine it to 3 hours. We're each going to present an hour of evidence and we'll each have half hour of argument. And we need a competent, experienced judge, and now we have one, who will keep things running down the middle of the road. But this is one of the issues. If you would, do you intend to do your deliberations after the evidence closes? There will be debate and consideration by council before taking a vote. And the question is, do you wish to do those deliberations in public or confidentially, as you may during executive session?
As for me, I'd like to see it done in public.
Me too.
So that the public can hear everything that goes on. I'm sorry, Mr. Baker, I jumped ahead.
It's all right. I'd just like to make a motion to waive the privilege of executive session.
For the purposes of deliberating on this
Yeah,
matter?
for the purpose.
I mean,
Second.
does that mean that whatever said in executive session, you're saying that it can be brought in front?
No, having
No, I'm asking, I want to make sure.
I hope that's what you're saying.
Be clear.
Can you repeat the question, Your Honor?
You're not saying that everything in the statements and stuff held in executive session can now become public?
That's the second question.
Okay, well, we'll get to that.
Right. This is simply, during this hearing, best example I can give you is, let's just say you had a an employee that you wanted to do something with.
Yeah.
You'd hear the evidence in public, you'd discuss it in private if you chose to, and you'd make your decision in public. But you don't have to do it in executive session. But that's the first question. In deciding this case.
Okay, let me check, let me get a vote on the first. All right. Are you, want to speak? Is that what you want?
No,
Okay, all right, okay. All those in favor? That passes unanimously.
That's right.
Let's hope that they understood what you just said.
So,
Go counsel.
I just want to be clear that this means that as the jury, your deliberation will not be done in private. Your deliberation as to this matter will be in public. Your discussion, your discord will be in public. That's all.
That's what we're saying.
Okay, thanks.
The second issue Your Honor alluded to is, will the council consider receiving into evidence testimony regarding previous executive session meetings?
Yes.
That's the question. Previous executive session meetings.
I would say, if you're going to do that, you're going to have to present the entire context of the conversation.
If I might, I think that's part of the adversarial process.
I'm just for the record. I'm making a statement for the record that if you're going to do that, it has to be in the context of which it was said.
Yes.
I just think
That's what we want.
okay.
So are these, do we have dated executive sessions, or do we have specific executive sessions that you are asking for it to be previously?
Not yet, not yet. I suppose we could do that. One thing we've also agreed is we're going to exchange by noon on Monday. We're going to produce to each other and to Judge Moore a list of who we may call as witnesses and what exhibits we might use, may use. We're going to list the witnesses, list of documents, and I'd be willing to list which executive session discussions that I would want to present in evidence, essentially a proffer. And you can rule on them one at a time. And in other words, there was a meeting, such and such a date, you discussed such and such, this is the statement I want to put in evidence.
Jackson, you would.
And again, you don't have to do that today.
Ralph.
Just a question.
Let's make it.
Is this typical for this kind of hearing?
I don't think this hearing's typical.
It ain't
Right,
typical.
so there's no precedence on this.
Precisely.
And so we're opening up our executive session for
Yes.
something that's not proposed as criminal activity.
And no city has ever done it before.
That's my concern.
Well, let me further illuminate. A city charter providing for the removal of a council member by the council it's unusual, but it's very similar to the federal impeachment proceedings where Congress is allowed to remove the president. It happens. If you Google it on the internet, you'll see that it does happen. But I find under Georgia law that it is, I haven't found a case involving this, and everybody seems to say, what's the law on this particular point? What's the law on that particular point? So, Dr. Rowell, you're right, this is unprecedented. And the comment I made regarding criminal matters is I was not retained to do that. I have not found any criminal conduct, and this is not a criminal proceeding, you're right.
Right, and that's what you indicate. So again, this is the second case that this council would be setting legal precedents.
One way or another, yes.
Well, actually, the term legal precedent actually in Georgia only applies to decisions made by the Georgia Court of Appeals or the Georgia Supreme Court. Decisions made by lower courts, and this would be considered a lower court, are not considered matters of precedent, but certainly this case will have an impact on Georgia law.
It would be what is considered persuasive authority.
Okay.
Okay, Mr. Khalid?
I just want to note that like we voted unanimously to deliberate in public and not go back into the room in executive session. So it just seems a little hypocritical that like now we're going to be public, but like everything that we said before, we're going to keep that secret. I mean, I think if we're going to be public, we're going to be public. I appreciate that you mentioned impeachment because, again, in that case, though the President of the United States has not been charged with a crime, that is not what the impeachment hearing is about. So I think that it's important that we separate criminality from ethics and a violation of the oath of office, because that is what an impeachment hearing is about. So, yeah, it has a motion been made to do this? I will make the motion to waive the executive session privilege of previous meetings regarding this matter, or however you would like to word that motion. Period. It back.
Second.
Probably second discussion, Ms. Rob.
Again, we talk about many things in executive session. So can somebody explain how you, I don't know what information you specifically want to gather, how do you deal with things that really are, I mean, it's a reason it's executive session. That's my concern. And then this really has nothing to do with Wilson. I'm talking about the whole body of discussion that we have. Is that redacted if it's not pertinent to the issue? How do you deal with that?
Everything comes out.
Well,
The hearing officer, right?
I think, exactly.
Anything that's, I would say that anything that is germane to the charges, and right now the charges are rather broad, as council will agree. I've asked for a bill of particulars. Right now I've not gotten that. So right now in my place, I'm going to say everything is subject, any and everything either one of you have said will be published.
So let me, am I finished? So I want our council to think about, we have talked about all kind of legal matters, municipality, all kind of things.
But it has nothing to do with this.
But what he said is that it's all open. And so I just want us to really think about the actions we're taking relative to this in particular.
Well, let me amend council's comments.
Okay.
I think what we're talking about is waiving the executive session privilege as it addresses conduct by Councilmember Willis.
Okay.
If there are peripheral matters, for example, if there had been, and I'm just being hypothetical, I don't know this to be true or untrue, but let's assume that the council met in executive session to discuss buying a piece of real property or selling a piece of real property. You don't want the buyer or the seller to know what your bottom line is, and you may have discussed your bottom line. So what I would be doing, this is common in a trial, this is common in a jury trial. You make a proffer of evidence to the court of what you intend to present, and the court does, and you use proper word, redact the items that, because there's the issue of Councilmember Willis's privacy, but there's also the issue of the executive session privilege as it applies to other unrelated matters, which are important, and those would be redacted.
I'm feeling better, okay. Because that's my concern. Like I said, set this aside, we deal with all kind of matters. So you're saying specifically to conduct.
And Judge Moore, we've alluded to that, and we'll have a conference call with her before Tuesday.
Okay.
And if you know her, she's a very experienced Superior Court judge. She's handled high-level felony cases. She'll understand your concerns, Dr. Rowell, and you'll be able to tell her your concerns.
Okay, that's all. It's the broader body of issues that we deal with that I'm concerned about.
I want to be sure, because he's speaking for his clients, I'm going to speak for mine.
Yep.
Okay.
As it relates to mine, if this body has a contract with Coke, for example, and in the executive session, you decided that you don't like Janet Jackson because she represented Coke, that's coming out.
That's what I meant when I said context. But anyway, Ms. Jackson, you're next.
Dr. Rowell, I do understand what you're saying, and I agree. Although the city of South Fulton has already set a precedence on several things before this. So I guess we're the ones
Right,
that's
and I
setting,
take-
yeah, but we've set precedence on a lot of things and a lot of lies. So we need to get to the truth. And if we have to get to the truth to go to executive session, to talk about the conduct of me, anybody, let's do it. I think we need to do it.
Ms. Gilliard?
So I honestly thought that whatever was in executive session that related specifically to the issue that we're dealing with, and anything related to that would be what would be revealed. Not if we, for instance, talked about coke, but did black coke. Because that wouldn't be germane to this hearing.
Right, that
So
would
do
be-
I have this clear, or am I not thinking about this right? Because I don't believe that everything that we talk in executive session needs to be, open to the public, only what is germane to this case.
Right, well,
And to
I was
this-
using,
and-
sorry.
And to this conduct.
I was using coke as an example. I don't know that, yeah, I apologize. What I'm saying though is, Judge Moore is, as he stated, is an incredible jurist. If we get into that type of dialogue, one, she's gonna know what to redact, what not to redact,
Okay.
what to allow in, what not to allow in. But if there's anything that is germane for right now, the charges are a hostile work environment, for example. That's very broad. So if that includes any other person that sits on this body that's had that same type of conduct, it comes out.
Okay.
Let me give you an example. In a typical trial, in a typical jury trial, the court almost always enters an order called an order in limine at the beginning of the trial. And what the judge is basically saying is, these are matters that cannot come into evidence. You can't talk about settlement offers, you can't talk about this, you can't talk about that.
Okay.
That's
The
right.
judge makes that ruling before trial, and that's one thing we'll ask Judge Moore to do, to enter an order that resolves this issue. And we'll let her know today or tomorrow to start spinning the wheels on this.
Okay.
You want your coke back?
Mr. Khalid, go ahead.
Yeah, well, first I just want to double down on that Judge Moore, in all of her decades of jurisprudence, will make the decision about whether or not we are moving outside of the bounds. And we all voted for her, so I think that we have confidence in her ability to do that. I do want to say that when I look over the decisions that we have made as a city for the past 2.5 years that I've been in office now, our worst decisions were always made out of fear. Someone always scared us into thinking, if you do this, or if you don't do that, then X, Y, Z. It's one of the reasons we still don't have a strategic plan. I could go down the list of all the decisions that we've made because we were rushed or pressured or scared into choosing or not choosing something. And I want us to be courageous in our pursuit of the truth. That's it.
Okay. Ms. Jackson?
I just want to be clear, because you're saying that Judge Wyatt she'll have the option of choosing. Excuse me? She has the option of deciding, what we talk about. I mean, what we can talk about or what can be brought from executive session. But you're going to give her what the charges are.
Yes.
So basically, that's all that should be coming, is the hostile situations that happened in executive session.
And anything that's not relevant to that would be disregarded and stricken by the judge.
Exactly, that's what I'm saying. So that's all we're looking for. That's all she should be looking for.
Okay, we'll give Mr. Baker, then myself, and then we'll vote.
Yikes, I was gonna call the previous question.
Oh, you can, go ahead.
Yeah. I can make a motion to call
Second.
the previous question.
Properly, moved and second to call the previous question. Any discussion? All those in favor? No discussion on the previous question. All those in favor? Okay, who wanna call the, did we make a motion, Madam Clerk, on the other?
Sorry,
On the floor.
motion on the floor
What is their motion?
to allow,
Go ahead.
okay,
I'm asking the clerk, go ahead.
to allow previous executive meeting information to be disclosed
As it relates to this matter is what I
as it
said.
relates to this matter.
Okay, that's the motion. All those in favor? That passes. Okay. Next item, Ms.
The
Clerk.
last item on the agenda is council approval of the subpoena process.
Now, this is interesting.
It's a fascinating legal issue.
When did you do this?
Pardon?
When did you write this? You wrote that? Who wrote this?
Well, I will, Your Honor, they say that defeats an orphan, but I'll claim it. Yes, I
Well, that's a
prepared
yes
this.
or no answer. Did you write it?
I prepared this morning.
And when did you give it to us?
At about, well, I emailed it to you at about, I finished it at about 1:30, and I emailed it to you at about 1:45.
Who did you get input from? I rest my case.
Myself.
Right. I rest my case.
Only because,
No, let me just say this. You do not have the authority to write something giving two council members the authority to be subpoena agents. You don't have that authority. If we voted, I'm just saying you should have talked to us and found out how we want to do that. I just saw this right when I got here today.
yes, sir.
I've been in a meeting trying to save the community from paying 5% increase in sanitation, something real, all right? And I just saw this. And I was shocked when I saw that.
Let me explain why. The rubber meets the road. As the attorney assigned to prosecute this case, I want testimony from Alvin Nash. He does not live in the city of South Fulton, and I have to have a subpoena to have him come here. Now, his attorneys are not saying yes. They're frankly giving me opposition for him to testify. Now, they may change their position, but and counsel for the Development Authority may take the position that this city council doesn't have the authority to issue subpoenas. I'm convinced as a matter of law this council does. And I think this council has the authority to issue a subpoena that's enforceable statewide. That's my legal opinion.
Oh, let me ask
That's
this.
why I'd ask for it.
Well, and speaking for myself, but though I want to be clear, I think the mayor's question is, who authorized you to say Mark Butler and Khalid come out, be the official subpoena officer?
Oh, well, I did that, and let me explain why. There's another legal provision, and that is that initially I thought, this is a case, as I said, of first impression. In most cases, in the state court or the Superior Court, an attorney of record is allowed to issue a subpoena. So Attorney Weems or myself in a normal case could prepare the subpoena, sign it, and serve it, and that has the power of contempt behind it. I don't believe that an attorney of record in this case can issue a subpoena on behalf of the council. I believe there's a Georgia Supreme Court case, and I believe it has to come from council. So I don't, just anyone
But sir,
that...
you're asking two voting members of this body
Correct.
to do this.
Correct.
Our constitution, our charter says that the face and voice of this city is the mayor. You never talked to me. I don't have a vote.
I didn't talk to anyone about this.
But I don't have a vote, sir. I don't have a vote. So it would seem logical that you could have talked to me about this issue and could have achieved the same ends. That's all I'm saying. You're talking to people who are dead set in line with this whole movement, and yet they're going to be serving subpoenas. I don't agree with that.
And if I might just add, and I said this to council, so this comes to no surprise. The Constitution doesn't allow it. The city charter doesn't allow it. The state law does not allow it. It is absolutely illegal, and if it passes, I intend to challenge it.
And that may be a basis for challenging these proceedings after they're concluded, or maybe a basis for an appeal.
Okay, that's always the issue. Ms. Gideon, go ahead.
So, I don't know about anyone else, but as far as I'm concerned, Al Nash needs to testify.
Precisely.
However that happens, if this is the only way that it can happen, how do we fix it so that we don't sit here and go back and forth and go through a lot of foolishness about it? But he needs to testify one way or the other. How do we do that?
In my opinion, with respect to anybody testifying, and I've said this to council, Judge Moore is a judge. She is vested as a Superior Court judge in the state of Georgia. As a judge sitting in senior status, once you have made the decision to hire her, it comes with the powers that she brings with it. If she, as a judge, then says, I hereby issue the authority for the subpoenas to be done by the city, and I issue that as an order, in my opinion, it addresses the issue. Now, if we were to serve a subpoena to somebody and they file a motion to quash it, that motion to quash will either be brought before Judge Moore or before the Superior Court of Fulton County. But Judge Moore would have to decide it before the Superior Court of Fulton County would even be able to get it.
Mr. Attorney,
And let me, I also.
He still has the floor.
I still have the floor. So I want to ask you, if we do not use this to get a subpoena to subpoena Mr. Nash, rather than to wait for the judge to do that, how do we get that done? How do we get a subpoena delivered to him? Because I think, well, right now I'm just focused on this one particular witness. How do we get him to accept a subpoena?
Logistically, yeah, here's the process. The service of a subpoena has to be served personally. It can't be done by certified mail. It can't be done by email. It's like a lawsuit. You have to be personally served.
Right.
Last Tuesday, when the court authorized the hearing on December 10th, the charter required 10 days notice to Ms. Willis.
First, you said the court.
I'm sorry, the council. You're the jury.
Okay.
The council authorized the hearing for December 10th. Councilmember Willis was entitled to 10 days notice. That gave me Wednesday, Thursday, Thanksgiving, Friday, Saturday, and council and Ms. Willis, didn't acknowledge service of process. They wouldn't sign on it. So I hired a process server at the expense of the city, and the process server went to Ms. Willis's house that night and served her personally. That's the only way to get Mr. Nash to appear to testify. Now, I also put on the council dais something that I emailed to you when I got it. It was the factual summary, short summary of events by Alvin Nash. I asked the attorneys for Mr. Nash if they would
Wait, I'm sorry, counsel. Yeah. They can't see that. That's a document that's not been certified. It is not a public record.
It's something that has been given to me by an attorney, from the Development Authority.
What attorney?
Sandra Zayak of Arnold Goldman Gregory from the Fulton County Development Authority.
We're not going to have a trial today.
Counsel, they can't see that.
But I think you make a point, Sean.
I just want to know how do we, all I want to know, my question hasn't been answered. All I want to know is how do we get Mr. Nash to come and testify?
To hand him a subpoena to testify at his place of work or at his home.
And in order for us to do that, we need this?
You got to vote. You got to vote to authorize those subpoenas.
For it. So can I make a motion that we vote to have a subpoena delivered to him?
To take their name.
Can we just do that? Do we need a resolution for it?
Well, we need a process one way. I'm sorry, my apologies.
No, I don't have the floor.
Well,
she still has the floor.
I'm just still trying to get to how do we do it?
We need a process for subpoenas to be delivered.
Okay,
We can either, one, take that guidance from Judge Moore,
okay.
or which I would certainly, and I've said to council, so this is not new to
I don't wanna do
him.
that.
We should, we certainly could do that. Or two, this body could do whatever it determines it wants to do. I will say that the law is very clear. The law says that subpoenas must be issued by somebody who's over the age of 18 and uninterested in the case pursuant to the Georgia Civil Practice Act. This body is not pursuant to the Georgia Civil Practice Act because you're not a court. You don't hold the powers of a court. And until Judge Moore sits, those powers, in my opinion, don't vest with you.
So, then this is my last one, and I'll give it up. So, what is your recommendation?
My recommendation is that the council authorize someone in the city government, member of council, alternative members of council, or authorized clerk, deputy clerk, city manager,
Oh, the city clerk.
city clerk or deputy clerk,
Oh, okay.
and to execute the subpoenas. Now, Attorney Weems may have a half dozen witnesses that he wants to subpoena. And so what he would do is he would prepare the subpoena and he would request that the clerk sign the subpoena. But everyone is nervous about putting their signature on everything, myself included. I mean, just today a clerk in the State Court of Coweta County said, just sign here and I'll fill it out. I'd rather read it first. So my point is, perhaps, it can be a member of council, it can be your clerk, your deputy clerk. I suspect maybe your city manager, but I frankly would like to stay away from that legally because I don't know. I think council, city clerk, deputy clerk, those are choices. As much as I respect Judge Moore, I don't know as a matter of law you can delegate the issuance of subpoenas to her.
Not the
I don't want to do that. I don't want to do that, but instead of making a motion, there are other people that want to, weigh in, so I'm just going to give it up right now.
Mr. Baker?
I don't know if we're stepping beyond the bounds of what was set for Judge Moore when we give her that authority, and I just wanted that to be stated publicly. But I'm okay with this document moving forward, and the names of the two council members being replaced with at least the deputy clerk. I don't know if there was an issue with this initially at some point, where our city clerk could have moved forward with the subpoenas. Is that something they couldn't have done some time ago, like last week?
Well, I think your city clerk would be authorized to issue the subpoenas, but I hadn't reached that legal opinion until this morning.
Okay. Well, I would like to authorize at least the city clerk or the deputy clerk to move forward with this.
That's acceptable to both lawyers.
I'd like to make a motion to approve this document, striking. There's a mistake, Mark Butler.
I know my current.
My intended name as well as Councilman Khalid's, and replacing it with the city clerk and deputy clerk's name.
Okay.
Okay. Well, the deputy clerk. That's the motion. I second.
Properly moved to second, discussion?
Yes.
Discussion.
Ms. Brown? I got you.
Again, I think it's probably appropriate to let the judge deal with this. It's an impartial body, a person. That it seems like y'all might have been on agreement with that, and I'd rather that be the case than to bring our clerk and deputy clerk. Is that something y'all can agree to? Do y'all
Well, I don't
have
think-
the same interpretation of law relative to this?
Yeah, I believe we do. I think we agree that Judge Moore cannot and should not be put in the position to issue subpoenas.
Oh.
But we believe that with her being seated, that she can help us identify the people who would be authorized to issue the subpoenas.
Gotcha.
And she very well might come up with the same people, i.e. because in other jurisdictions, it's either the clerk of the court or the clerk of the city that's authorized to do it.
So given that, would it be appropriate? Okay, I'll leave it at that.
Okay.
Maybe her turn.
And I'm happy to ask her. We're gonna talk with her this evening. We happy to ask her that.
Okay, Ms. Gomes?
So will our city clerk and deputy clerk be exempt from testifying?
No.
So how would they be the ones to actually
Well,
issue the subpoena?
I'll state in my place that I have no intentions of calling either as a witness.
And I will state in my place that if anybody who was in those executive sessions are subject to being called.
Yes.
So they are a part of our executive sessions?
That everybody who was in there may be called.
Just for clarity.
She still has the floor, Mr. Bacon, I get you.
I do.
Yeah, I just wanted to put, for clarity, I don't know if our deputy clerk
They're both in there.
is in every executive session, but I know our city clerk is, and I think that I did change that motion to just say our deputy clerk. How you back up, Councilwoman?
There were a few times that before our current clerk was available, that our deputy clerk actually served in those executive sessions. I think probably the ones that may be pulled, I know he was a part of. So I'm just trying to figure out, you know, who else, other than the more that could be impartial.
Do you have a clerk of your criminal court?
You what?
A clerk of your municipal court.
I'm sorry, sir.
Oh,
Is there a clerk of your municipal court?
Yes.
yeah.
If y'all will allow, if this August body will allow us to confer with Judge Moore on this, I would imagine she
No,
might.
I'm sorry, but I'm still waiting to speak. We have an order of people.
There's a discussion, I'm following the order, the gal's.
But I still have the floor, so I'm sorry, go ahead.
Go ahead, you still have the floor.
I just, if we're willing to certainly go and speak with Judge Moore and see if that's something that she would agree with, I think we both think and I just spoke with him that the clerk of the municipal court may certainly suffice to be able to issue the subpoenas, because they are set hours.
Full-time employee.
That's all I was about to say. Is she a full-time employee?
Yes.
She's a full-time employee.
Yeah.
There are set hours.
Okay.
She would be available.
Yeah,
Yeah, municipal clerk.
she's still there.
Okay.
Ms. Gomes, you still have the floor.
So who made the motion?
Yes, because that's-
I made the motion.
I would ask to see if Councilman Baker is open to possibly exploring an alternative of having our municipal clerk actually serve the subpoenas.
With all due respect, I think that the further and further it goes away, given that it is time sensitive, we're just looking at a week from now. If that was a substitute motion, that would be at your discretion, but I would like to keep it the way it is. Our counsel has advised that he doesn't plan to call either one of our clerks. If it's at the discretion of Attorney Weems to do so, he's the person that would be working against that as well. So it would be his discretion, and we would be welcome into that under his discretion, even if it doesn't come from our clerk. That would totally be opposing counsel.
Okay. Did you yield? Is that what you did?
No,
Okay.
he rejected.
Mr. Khalid,
Thank you. I have several questions. First, I want to go back to something that Councilman Baker said. How did we get here? Did we have a problem issuing subpoenas before? Is this brand new to today? Or did something happen where we needed to have a meeting about this?
We did.
To do this. What happened?
Because this wasn't in, we had a call for a hearing last week, and this wasn't part of the conversation. So I'm just interested to know, how did we get here?
The,
Tell the truth.
well, the first, one issue at a time. The first issue is you have to designate a, quote, special hearing officer. I didn't have anybody lined up last Tuesday. this growing city has had meeting locations in different places. And so these were essentially the housekeeping tasks. To answer in general terms.
Okay, so my,
And I'd rather not have to serve subpoenas, rather not waste.
right, no, that's fine. So it seems like there are two issues and two legal questions. One, the issuance of subpoenas and who has the power to do that, and then the serving of subpoenas.
That's not a problem.
That's not a problem, that's not a problem.
That's not a
The
problem.
serving is not a problem.
Anyone in the room
Can
can
serve
serve a
subpoena.
subpoena.
As long as they're not interested, they're not gonna be part of the witness.
So,
Or typically you would mail in a check for $50 and the Fulton County Sheriff's Office would serve a subpoena.
right,
But
so why
it'll
could
take-
we not do that? It sounds like you
Because it'll
served a
take 'em-
subpoena.
It'll take them a couple weeks.
Yeah. they
So
won't-
it sounded like you served one within one night with a process
Yes.
server.
Yes.
Could we not just do that? Could we not just hire a process server to serve these subpoenas?
But the city would have to pay for each and every person, each and every attempt.
How much is that?
And the subpoena has to be
Certified.
executed, has to be properly executed. Otherwise, if for example, let's just say that I prepared a subpoena for Alvin Nash to appear, and there's no signature on it, okay? It gets served with a $25 witness fee and mileage, and it goes to his home, wherever he lives, I don't know where he lives, and it's served to him at home. His lawyers in downtown firm are gonna say, this isn't a valid subpoena because it's not executed by someone, or it's not executed by someone with authority.
Right.
It's executed by someone who has no business executing a subpoena. So it's got to be properly executed, and that's a ministerial act. There's no liability
It really is.
by the party who does it, but it just shows that it's been properly issued, and then it's served by anyone. Now, the process server happens to do this for a living, and charges for it, and knows how to do it. And that's why we're able to do it 9:30 Tuesday night.
I did not, I didn't think of the fact that there has to be a witness fee, I would imagine.
For Mr. Nash.
For any entity that is gonna be testified.
Right.
So this body is gonna have to authorize, and your question was, how much does it cost? For, I don't know, how much does yours got charged? Usually anywhere from like 60 to 80 bucks per attempt.
And you all said that you would confer with Judge Moore. When is that going to happen?
Tonight.
Next couple
We
days.
plan to, we told her
So-
that we would talk to her tonight.
Because it sounds like you would have to confer with her and then we would have to meet again.
No.
No,
There would be no more meetings, just
No.
whoever she says?
No.
whatever we all agreed to, we would just contact the mayor, as the chief spokesperson of the city, and together advise, I would imagine, that that's what we
Well,
would, or the city, when our issue witness.
I don't think Judge Moore would have any authority to override a decision by the council. But I think in terms of logistics of all these issues, she needs to understand what you've done. I don't think she has or should be given the power to issue or resolve the issuance of subpoenas, because it's the law. It either, you know,
Yeah.
we disagree, and either the subpoena, it's an interesting legal issue, but I don't think she weighs in on that issue.
I don't even think she would, if we asked her to weigh in on that. The only thing that she would weigh in on is
You could-
who's authorized to sign the subpoenas.
You could, among your options, or many options, you could pass a provision providing for the execution of subpoenas subject to Judge Moore's approval.
Yes.
And unless she has a good reason, she would likely approve the council's decision.
That is true.
Okay.
So to be clear, the substitute motion would be to authorize our deputy clerk to issue the subpoenas subject to the approval of the judge.
Yes.
And just for clarity's sake, because I like to think things all the way through, if the judge says no, what then happens? Will we have to come back?
No, because the three of us, I would imagine, would then have to come up with the process.
I'll deal with it. I'm prepared. I'm prepared for the alternative.
All right. Well, I will make that substitute motion.
Okay, we're still in discussion. Mr. Baker, you had spoke before when you still want to speak?
No.
Huh?
No.
Okay. The clerk wants to say something, and I want
I think Councilman Khalid raised a valid question. All of this is supposed to take place before next Tuesday.
Yes, ma'am?
This means identifying these witnesses, getting them there. Is that sufficient time?
I'm prepared to go forward.
Okay.
Okay.
I'm prepared to, I mean, I've got to put it together, but I'm nearly ready to give council the exhibits I plan on using and the witnesses I plan on calling.
And a bill of particulars.
Perhaps. Perhaps.
All right, you want to say something, Clerk? Let me just end this and we'll take a vote. A couple things. One of your comments was that you hired a process server at the expense of the city.
Yes, sir.
Madam Attorney, is that a part of the contract? He can go out and hire who he wants to at our expense?
So your current approval is for him to represent your interests?
Absolutely.
At the hourly litigation rate, which is $180 an hour. I would say that is a process that is incidental to his representation of you.
Yeah, but he can make it $180 an hour.
He's not.
There's nothing in, hold up. There's nothing that I saw in the contract that allows him. And this is why I said that, because I've talked to him a couple of times and he is, in my opinion, has gone a little bit to the left too much in terms of his authority, even as our attorney. And so as I look at the fact that you got more process service coming, if he's going to represent us at this rate he is, if he wants to get a process service without our knowledge or without our approval, then he can pay for it.
Let me explain why I hired a process server.
I know why.
Tell us why.
Because
Everybody go to the left.
I know why, sir. All right,
Either
back
one to the left.
All right, so let's vote.
What are we
The
voting?
motion
Second
again,
motion.
reset the meeting.
I do have a question.
Call for the vote.
So, part of that executive session. How to know?
The motion was made by Councilmember Baker, second by Councilman Khalid. Move to approve the resolution with striking Councilmember Baker's and Khalid's name and substituting it with the deputy city clerk.
There was a substitute motion made.
It wasn't second.
Yeah, I second. The substitute motion? That was pursuant to the judge's approval?
We didn't get the second on it. We didn't hear a second.
Okay.
But
What's the process? Okay, well,
Well, you can always make another vote. We'll vote on this motion, Ms. Baker, and you can always make another. All right. All those in favor?
But I have a question.
Why are you raising your hand that way?
I got a question.
we heard the substitute motion, but we did not hear the second because I asked.
It's okay, because we
No,
got.
Ms. Bagby, I do want Ms. Gunn to ask a question to the attorney. Go ahead, Ms. Gunn.
So again, we're going to be pulling executive sessions. We don't know how far we're dating back to those executive sessions, correct?
No.
Okay.
We can go
So,
to the inception of the city.
all the way to the inception of the city.
Very first
So
night.
there will be probably a couple other people that will be subpoenaed. But my question is, again, when we had the transition of our former clerk, then we had our deputy clerk. So he may also be subpoenaed in the process. I don't think y'all are understanding what I'm asking or saying, that he's also gonna be possibly subpoenaed. So that's why we're asking for someone neutral as a municipal judge that sits for the city, and I don't know how that may impact our time.
Yeah.
Because our current Ms. Whitewood hadn't been here probably along the same time. So we're putting him in that position as well. So that's why I made the amendment, to see if the municipal clerk could possibly be the server.
They refused that.
He did refuse it, but I'm just asking,
Yeah, I did.
is it?
We've heard everything. I'm looking for a motion to adjourn.
No, I have a motion.
You have to carry that motion.
Okay. All right, let's vote. Let's vote. All those in favor?
In favor of what?
In favor of your motion.
Read the motion
Approving
again.
the resolution, changing the names from Councilmember Baker and Khalid to the deputy city clerk for subpoena purposes.
All those in favor? That passes. 4-3. All right, can I get a motion to adjourn?
I make a motion to, a substitute motion to amend the previous motion so that it is subject to the approval of the judge.
Thank you.
And I have 2 more motions to make after that.
Second.
Probably move to second discussion. Hearing none, all those in favor? Passes 5-2. Go ahead, Mr. Khalid.
I have another motion to authorize Mr. Morosek,
6-1, okay.
I have another motion to authorize Mr. Morosek to hire process servers as necessary for the carrying out of this hearing.
Second.
Probably move to second discussion. Hearing none, all those in favor? That
How much
passes.
is that gonna cost?
Are you voting for it?
I voted.
Okay.
All right, and then I have a final motion to amend the location of the hearing from the Cliftondale building to the South Fulton Arts Center. I was told that we can use the Arts Center, just not the stage area. So we'll just be limited to the floor, but that is a larger space. I want to make sure that we can accommodate as many people as possible. So my motion is to amend it. It's the same address, 4645 Putnam Road, 30349.
Second.
Probably move to second
Well,
discussion.
can I say procedurally, you do a motion for reconsideration?
I make a motion for
Approve the motion for reconsideration.
Yes.
Second.
Probably move to second, a motion for reconsideration.
Yeah, motion to reconsider the
Yeah, I
hearing.
got you, I got you. All those in favor? That passes.
Now I make a motion to, now I make a motion to amend the hearing location from the Cliftondale building to the South Fulton Arts Center.
That's what I asked
Second.
in the first place.
Probably move to second on discussion, hearing none, all those in favor? That passes.
I make a motion that we adjourn. I make a motion
Oh,
we
second.
adjourn.
Probably move to second that we adjourn, all those in favor?
Yeah.